Appeal are heard in the matter of Solicitors Regulation Authority Limited and Soophia Khan and others.
Mr. Alquist.
Thank you, my lord. My lords, when we finished yesterday, I had just taken the court through the authorities which we say are potentially helpful, or at least the guiding principles for the admission of fresh evidence, where it concerns supplemental material after the event, after the time of the trial. My Lord Justice Newey invited me to focus on perhaps the headlines of the actual underlying evidence. I'm going to do that now, quite succinctly, by reference principally to the first witness statement of Ms Hodgson, which we have in the Respondents application bundle, tab 2. As one would expect, my lords, the headlines of what you take from the exhibit are in there. So we'll go through that in a moment. But there are 2 points which I'm going to take as examples to show how the underlying documents relate to the summary in the witness statement, and to show in my submission the strength of the evidence. But there is another reason for doing so, which I'll address before we turn to the detail. And that is that I need to make submissions later on the main appeal on what is sometimes in the authorities called the appearance trap, whereby a court thinks that a person can participate in the hearing because they appear to be doing so. But in fact, the medical evidence shows that they can't. And my learned friend effectively took this point when he said yesterday that the judge leapt to a conclusion from Ms Khan's participation that she was fit to participate. In dealing with the main appeal, I'll go through the confidential schedule and show, I hope, why that is just not an accurate summary of the learned judge's reasoning. But I mention this now because I want to do the same process in respect of a couple of the examples in the exhibit that I take you to show that if the court is with me, that it should take this information into account. I am not inviting you to fall into the appearance trap either. Because we do accept, the authorities are clear about the importance of getting this right, especially in the case of mental health, and that the same must apply to autism and other conditions of neurodiversity. So I'll deal with the law on that and the points on the main appeal in more detail when I come to that. But that's why we're going to look at it in the way I proposed this morning. So, my lords, with that preamble, might I ask the court to turn to page 11 behind tab 2, where Ms Hodgson essentially introduces the points as follows. It says, I'm aware of the following, paragraph 7 of the witness statement, I'm aware of the following events which have taken place after the Leech order. These events, in particular their role in them, appear to be inconsistent with the position asserted in the appeal about the appellant's inability to plead and or stand trial, and or her inability to understand the proceedings, as detailed within the skeleton dated 29th of August 2023. Well, the 2 points I'm going to look at in more detail are first, those points which concern applications presently before the court, or connected with the appeals currently before the court, I should say. And secondly, the slip rule application that was made before Mr Justice Leech, ultimately in July 2023. And the relevant chronology starts at paragraph 9. My lords will have appreciated from my learned friend's submission yesterday that they found themselves in some difficulty in terms of the apparent inability to take instructions from Ms Khan, as at the 8th of March, on their reading of Dr Gupta's report, and the difficulty arising from the fact that the learned judge had disagreed with that. Now, I don't know, and it would be wrong to inquire whether that's connected with the conflict that arose, but ultimately Ms Khan wrote on the 4th of April, filing and serving a notice of change of acting on the basis that a conflict had arisen. And the reference for that one can find in page 5 to 7 of the exhibit, which is 26 of the bundle. conflict point actually comes in the application notice, which follows shortly thereafter, but I'm about to turn to. So we have on page 5 of the bundle an email to Claire Crawford and Gabrielle Hodgson, who are the solicitors at Capsticks.
When you say page 5 of the bundle, it's
Sorry,
page 26 of the bundle.
Page 26 of the bundle, page 5 of the exhibit. The email's sent to Claire Crawford and Gabrielle Hodgson, who were at the time the team at Capsticks involved in the case, and Paul Byrne, who was the learned judge's clerk. As far as I know, still is, but wasn't at Material Time, certainly the learned judge's clerk. And that files the notice of change of acting and says, for clarification, I will be acting in person in my personal capacity and as director of the second defendant and the third defendant. That sets out, quite clearly, the fact that where just for public is named in the notice of change of acting, it is in substance, at least in part, if not in whole, Ms. Khan herself who is doing the running on that. There are some documents signed by Mohammed Tayyib Khan as well, but we have Ms. Khan here saying, I will be acting in person. The notice of change is at page 28 of the bundle. And then the next step, my lords, follows immediately at page 29. And that was an application made on the 12th of April 2023 for an extension of time.
23?
12th of April 2023, page 29 of the bundle. An application for an extension of time to file the main appeal. And for an extension of the stay of execution on the warrant of committal, pending the filing of the appeal and determination of a stay application by this court. And that's the document which sets out in box 10 that a conflict has arisen. Ms. Khan's acting as a litigant in person. She says she's making arrangements to instruct a new firm of solicitors. That's the third paragraph. And she makes the point that she will suffer prejudice in the fourth paragraph if my applications for extensions of time are not granted, essentially because of the need for representation in order to give effect to her right of appeal. Now, my lords, the point I want to take on this is not only that Ms. Khan here is acting in person, but that she's making very valid points.
Yes.
This is precisely what should be
It's
done.
a coherent argument.
Exactly, my lord. It is an argument which demonstrates an understanding of the CPR, understanding of the effect of his lordship's order, and what needed to be done to obtain an extension of time. And one sees the same in correspondence starting at tab 35, that's page 35, further correspondence with the court. We go in the usual way with emails. We have the most recent email first. So I might ask the court to look at 36 first. And that is an email to the learned judge's clerk, following some previous emails effectively chasing for an outcome on the application, in which Ms. Khan, and one sees it signed by her personally, as well as with the footer of Just for Public Law, Ms. Khan is explaining the steps that she has taken in the meantime to progress the new solicitors. Again, my lords, a very relevant point. This is page 36. To put to the court. Now, one may take a point about whether an email to the judge's clerk is the right format for new evidence to go in on an application, but the point is that the relevance is clear, the understanding of the relevant questions is clear. My lords, keeping with chronological order, as Ms. Hodgson does in her statement and exhibit, the next major step is the start of the slip rule application. And for that, I would ask the court to turn up page 43 of the exhibit. We have a letter of the 20th of April, so just a day or so after the emails we just looked at. Again, it's signed by Soophia Khan. It says, and director at Soophia Khan Limited, so it makes it clear that she's writing in all three capacities, I think. Certainly herself. And she makes the point here that the order that Mr Justice Leech made on the application for an extension of time, incorrectly, she says, refers to all three defendants as respondents. And she asks for this to be corrected under the slip rule. Now, once again, without wishing to labour the point too strongly, it is a clear, coherent letter. It makes reference to a plausibly relevant provision of the CPR by its normal name that all lawyers know. Demonstrates a clear understanding of the proceedings. And my lord, that is correct, even though, as the learned judge ultimately found when he dealt with the application in July, it wasn't an appropriate case for the slip rule to be exercised, but the correct avenue was an appeal. That is a mistake that many lawyers have made over time, and certainly doesn't suggest any inability to understand legal proceedings. We have the transcript of the hearing which ultimately resulted. There's a formal application at tab 6, a letter with enclosure at tab 7. It was dealt with on paper first, and then there was effectively an application to renew that orally. But just focusing on really the key points, we have the transcript of the hearing at tab 11, page 203 of the bundle. And, my lord, one could read this at length, but obviously it would take some time. What I really need to point out is the first page, where it says that I appeared for the claimant, the SRA, and the first defendant appeared in person. I think the fairest way of summarising what happened then, although we do actually have this elsewhere in the bundle, is to say that the learned judge dismissed the application, but also dismissed my application both for indemnity costs and for the application to be certified as totally without merit, having had approximately 2.5-hour hearing to determine the point. And so the point is, my lords, on that, this was not an application in his view which was wholly irrational, bound to fail, disconnected from the relevant issues. May have been ultimately wrong, but not outside the norm and not bound to fail. Again, my lords, it shows an actual engagement with the issues.
Sorry to interrupt, my lord, but my learned friend, I'm sure, was coming to this. The skeleton argument was in fact drafted by counsel, myself, and the court actually makes note of that and thanks counsel for that. It wasn't drafted by my client.
Well, my lords, that is entirely correct for me, accept that. But it doesn't undermine the point that Ms. Khan appeared in person and argued the appeal as the advocate on her feet.
Well, and one can see from page 204 that in addition to Mr. Bogle's skeleton argument, which Ms. Khan referred to, she had also prepared her own note responding to your skeleton argument.
Yes, my lord. And I have briefly lost the copy of that. That is in, yes, tab 9. Title in the index refers to the covering letter first. Tab 9, page 199 is the note in question, my lord. And that is not signed by my lord.
Sorry, I wasn't keeping up. Which
page 199 of the bundle, which is behind tab 9. Tab 9 starts with Ms. Khan's letter, again sent by her person, enclosing a short respondent's note. And we have the note of 199-200 that my Lord Justice Arnold just referred to. Well, as that perhaps indicates, in giving the headlines, I'm trying to do that, and there is more if one looks into exactly what Ms. Hodgson has said in detail and the documents in the exhibits. There is more detail of exactly.
Well, there's
everything.
more of the same.
There's more of the same, exactly, my lord. More iterations of how this case has been, or these cases have all been conducted. But my lords, I think that is everything I need to say on the slip rule application to demonstrate that the evidence subsequently shows Ms Khan is actively engaged and perfectly capable of understanding the proceedings. The other, my lords, is what I call the 2022 appeal. That being the appeal against Mr Justice Leech's decision and committal order of the 12th of January 2022.
Is this 829, is it?
My lord, I've got 1094 in front of me, but I think, yes, it is 829. I've turned up. Yes, my lord, it is. I turned up the SDT second appeal instead. Page 281 of the bundle, my lord, which is tab 24. This is 829. And again, my lords, the first point to make on this is that this is just for public acting. There is no extra representation in terms of the conduct of this bill, and indeed that remains the case to this day. As my learned friend explained yesterday, he's instructed by Jane's solicitors for 868, the main appeal, but instructed by direct access by JFP, and indeed Soophia Khan and co, and I must also be therefore Soophia Khan, on 829 and the 2024 Companies Appeal.
So when you say direct, I'm not sure it matters, when you say direct access, this is an appeal by Ms Khan herself against the 2022 committable, and her solicitors are just for public. So,
my lord, I'm not sure it matters, and it is an area of some controversy. Just for public is on the appellant's case, is a non-profit legal organisation which does not require authorisation pursuant to transitional provisions of the Legal Services Act. There is a barrister employed by Just for Public. It has two directors, of whom Ms Khan is the other. She has no practising certificate. There was an injunction obtained, granted by Mr Justice Fancourt back in late 2011, preventing Ms Khan from exercising reserved legal activities.
You don't mean 2011.
No, I don't.
2021.
2021, before the first committal, preventing her from exercising reserved legal activities. Whether she has continued to toe the line on the right side is an issue of debate, my lords, which was not before the learned judge.
I understood you to be putting this forward as a document that Ms Khan had personally procured, was responsible for, but if you look at the signature on page 289, is that her signature? I don't think it is it?
No, it's not, my lord.
So who is that?
That is Mohammed Tayyab Khan, which is the full name underneath. There are, as we understand it, two directors of
That's
Just
her,
the Public. This
that's
is the
Ms
other
Khan's
we
brother?
we believe to be a relative, yes.
And if that's right, it's signed by Mr Khan, what reliance can we place on the fact that it is issued as indicating anything about Miss Khan's
Well,
position?
2 points, my lords, on that. The first is that Mr Khan, even if he is acting as a legal representative via Just for Public Limited, must be taking his instructions from somewhere, just as my learned friend must. And the other point, and Miss Hodgson deals with this at various points in her witness statement, one sees the metadata of documents when they've been served, showing that they have in fact been prepared or edited by Ms Khan herself. So, for example, at 323, we have the index, the metadata displayed from the index to the core bundle, which shows that it was last modified by Soophia Khan. There are various examples of that throughout the bundle. Another example, my lord, 338, an application for an extension of time to make substantive representations in support of the appellant's request for reconsideration of my Lord Justice Newey's decision of the 17th of July. That application notice, we have the metadata at 346. Its author is Soophia Khan.
Thank you.
You don't need the metadata, my lord, because the other point, as I said, is that Mr Khan must be getting his instructions from somewhere. But we believe it to be Ms Khan, just as she has been corresponding with the court in the run-up to this hearing about 829. The other point to emphasise, my lords, there are various points, just to run through the headlines in Ms Hodgson's evidence about the 829 appeal. I've shown you the appellant's notice. There's also the application to rely on fresh evidence in the form of Dr. Rajpal's report dated the 14th of April 2023. There are reply submissions made to our objections to that. They're described at 33, various references to exhibits. There's an addendum to the psychiatric report, 8th of June 2023. And there are various points around the correspondence between Just for Public and Capsticks 34 to 36. Correspondence and applications for extension of time 39 to 40. I've just shown the court one of the documents referred to there. And also, for the sake of completeness and scrupulous accuracy, given what my Lord Justice Nugee has just said, I should probably also mention that Ms Khan has filed a cost schedule in 829. In which
Filed a
cost schedule
Yes.
for the application in 829, in which some time is claimed for advice and work on documents by Mr Mark James of Council. So it may be, we don't have the details, it may be that behind the scenes there has been advice from Council. But again, the same point applies there. Council must be taking instructions. The final point, my lords, on the 2022 appeal in 829 is the fact of Ms Khan's reliance on Dr Rajpal's evidence. And this brings me to 2 points, effectively, that I'm going to make by way of conclusion. The first, might I ask that the court turn up tab 25 of the Respondents application bundle.
Page.
293. This is, of course, before the court on 829. As my Lord Justice Arnold mentioned yesterday, it doesn't automatically mean it's before the court on 868.
So this is Dr. Rajpal's original report.
Yes, my lord. Ah, let me just check, my lords, that I am right to refer to this. Yes, my lord. This is his original report, but it is relied on in the appellant's notice in 829 of the 2nd of May. It was also relied on in the SDT appeal, which is why I wanted to check I wasn't making a mistake. And given what my lord indicated in terms of approach yesterday, I won't read out the repetition of Dr. Gupta's opinions or the diagnosis and in detail and so on. 1.4, Dr. Rajpal makes clear that the diagnosis would not impair the appellant's ability to form mens rea for her actions. That the reduction, this is 1.5, the middle of 1.5, any reduction in her ability to imagine options available to her cannot be quantified, and that the deficits she had on balance might have impacted on her ability to decide in August, September and October 21 about the appropriate action. That is temporarily different, my lord, of course, because this is 829 against the, in respect to the trial in December and the underlying findings of contempt. It mentions of 1.6 increased vulnerability to suffer with anxiety and depression under stress. And my lord's 2 points on this. The first is that this is not on its face at all consistent with Gupta 2 in terms of what Dr. Gupta says the impact on the appellant is. And that's one of the points I rely on in saying that it would be wrong for the court to shut its mind to the appellant's evidence in 829 when considering the appellant's evidence in 868. That sort of inconsistency is something that the court should take note of, and particularly in circumstances where it's all being dealt with at the same hearing. The second point is on 1.6, that the diagnosis increases her vulnerability to suffer with anxiety and depression. And here I wanted to come back to a question my Lord Justice Arnold asked of my learned friend yesterday morning, which is how the connection is made from Dr. Chowdhury's diagnosis of work-related stress to Dr. Gupta's diagnosis and the question of fitness to plead. Now, I'm not sure if I followed my learned friend's answer fully, but to me it sounded that he was essentially saying, well, it was just demonstrating that there was an issue as to her mental state, and that should have put everyone on notice and the matter should have been investigated. In fact, the appellant's case, at least as it's been articulated in the documents, is different from that. It is that her diagnosis meant that the stress was more severe, and as a consequence, that Dr. Chowdhury's report, and indeed what Dr. Rajpal is saying, is more relevant. I think that might actually be the correct answer to my Lord's question. Now, that is dealt with, just to give the court the reference and also introduce my final point, in the appellant's applications bundle, because it obviously posts the relevant report from Dr. Rajpal post-dates Hodgson's witness statement. And that is the supplementary psychiatric report, appellant's application bundle, tab 37, starting at page 245. And on page 247, one sees what the instructions are. And in particular, for today's purposes, the relevant point is 2.1a, which I might ask the court to read.
Sorry, I'm now lost. Where are you?
I'm in the appellant's application.
Single bundle.
The single bundle.
Single bundle.
Am I right in thinking there are only 2 reports from Dr. Rajpal?
There are 3. There is an addendum as well, which explains why the impact of the diagnosis on her ability to deal with stress cannot be quantified. And essentially it says it's a qualitative exercise, not a quantitative one. I can give my Lord the reference to that in a moment.
But this one, which is dated 30th September,
Yes.
and what was the passage you wanted to
To
look at?
start at 247, just to be clear on what the instructions to prepare a supplementary report deal with. Paragraph 2.1a. And 5.1 on page 248 is the evidence in question. it deals in more detail with the links between stress and her diagnosis. Now, my lords, I will confine myself today now to pointing that out as being there, and make my submissions on what weight should be placed on that evidence on the application that it's actually tendered in support of, once that application has been made. But on that page, and this is, I think, an important point, the last sentence of 5.1, halfway down page 248, Dr. Rajpal says, autism itself is not enough for defendants to become unfit to plead, engage, or instruct. So we are in a situation where the evidence put in by Ms. Khan on 829 is contrary to her case on 868. Now, it's fair to say Ms. Khan doesn't adopt that particular paragraph or sentence of the report in 829. It's not that she's running inconsistent cases, but she has adduced inconsistent expert reports. And my lords, I do submit, looking at the authorities and the breadth of the test we looked at yesterday, that it would be wrong in terms of the overriding objective and the discretion to admit fresh evidence for the court to shut its mind to that when it considers my learned friend's submissions about whether there should have been an adjournment to deal with further evidence, and whether Dr. Gupta's report is merely being criticised because it was prepared quickly. The final point, and this can be made very quickly, which picks up on something my Lord Justice Arnold said, and I've reflected on it overnight. My Lord said yesterday, well, the fact that it's before the court on 829 doesn't mean that it's before the court on 868, and you still need to make your application. I think, following that logic through to its logical conclusion, I do also therefore need to say that I seek the court's permission to rely on the documents filed in 829, which post-date Hodgson 1, and therefore weren't exhibited to it.
Yes, so to be clear, where that would particularly bite is with regard to, I know we've been calling it Rajpal 2, but it's in fact Rajpal 3, which is the one you've been referring to just this second, because Rajpal 1 and 2 are exhibited to Miss Hodgson. So if Miss Hodgson comes in, they come in.
Yes.
But she doesn't exhibit Rajpal 3, because that's later in time.
Exactly, my lord. And I recognise there's no application notice, but what it effectively would have done is simply say, for all the same reasons, please also read the other documents that are already in the bundle. It would also bite not only on Rajpal 3 is perhaps one of the most significant documents, but it would also bite on the submissions that were made to my Lord Justice Newey on paper in respect to the reconsideration decision, which was made in November, the supplemental skeleton, or the skeleton argument which was made on the set-aside application, which the court will have to consider tomorrow, or possibly today, and indeed on the company's appeal as well.
I mean, it's certainly quite difficult for us to take into account certain materials on one aspect of what we're hearing and ignore them for another aspect of what we're hearing.
It's possible, my lord.
It
Civil
is
judges
possible.
do that,
Yes.
but in my submission it's entirely unnecessary, because while there may be cases in which the detail of what has gone on subsequently is so complicated or controversial that there are case management reasons to exclude it in the interests of finality in the administration of justice, this is not such a case.
Well, and there's another point too, which is, I think what you're saying, but let me make it explicit, is it cannot be right for a litigant relying upon medical evidence which she has obtained to seek to compartmentalise the use of that medical evidence so that it's only available for her appeal or in one of the appeals and not in one of her other appeals.
My lord puts it better than I did.
Either
yes,
she's
precisely.
relying upon the totality of her medical evidence or she's not.
Exactly. It is, frankly slightly absurd to ask the court to compartmentalise the evidence in that way.
Yeah.
Well, unless I can assist you further on our application for fresh evidence, that's all I think I need.
Just to complete this, you mentioned Rajpal, what we might call Rajpal 2 a moment ago, and said you'd identified.
Oh, yes.
That's 315, is it, in your bundle?
Exactly, my lord. Tab 28, page 315. And in terms of substance, it's a single page, 316. It's described as an addendum to the psychiatric report, which might be why the 30th of September report is often called Rajpal 2.
So it's more like 1.5.
1 and 1.1 and 2. Yes, my lord.
And it's some degree of amplification. I'm not sure it changes anything.
No, I don't think so, my lord. That's why it's not one of the headlines that I picked.
Yeah.
Well, as far as I should just come back to this to make it clear, as far as the rest of Hodgson 1 is concerned, we do rely on it for the headlines that are stated. But ultimately, it really just tracks the factors that my lord, that Mr Justice Leech mentioned below, such as television appearances and so on. Those are the key points, the ones that I've made.
Yeah. Mr. Bagel.
Well, I may need to take instructions on 1 or 2 points that have arisen, which haven't appeared in anything hitherto. So I may have to come back to you on that if the Lordship allows. But my submissions in reply will be relatively brief. The normal position is that fresh evidence will not be admitted by an appellate court unless it meets the requirements in Ladder Marshall. And in my submission, this evidence does not, because the appeal deals with what happened up to and including the committal hearing, not what came after, which goes to her state of mind at a time which is not relevant, i.e. after the committal hearing. Her condition, moreover, might be fluctuating, and that has been suggested, but I can only repeat my primary submission and the gravamen of my submission, this time not to the point of overstating I have. We won't know until there's further medical evidence. That medical evidence is still required. It is admitted inconsistencies between the medical evidence that would be before your lordship, if your lordship allows the evidence in, and that applies equally to my client's application in respect of that evidence, whether it includes Dr. Rajpal or not, and also Miller and Friends. And those inconsistencies are only going to be cleared up by some additional medical evidence.
I mean,
But for the moment,
sorry, 2 things. One, in terms of Ladder Marshall, so far as Ladder Marshall may matter, let me just remind myself of what the actual Ladder Marshall criteria are.
they could have been obtained with due diligence, that it is sufficiently coherent to be able to make a difference to the case, and can't remember the third.
No, I mean,
It's page 1803. Could not have been obtained with reasonable diligence for use of a trial. Must be such that if given it would probably have an important influence on the result of the case, though it need not be decisive. And 3, it must be such as is presumably to be believed. Apparently
That's
credible.
Credible, in short.
so were we to approach this on a Ladder Marshall basis, I mean, plainly this evidence wasn't available at the time because it's only come into existence later. It's such as one might believe. So the basis for excluding it on Ladder Marshall grounds would be it's not likely to have an important influence.
Exactly.
Can I just ask
indeed.
you about that, because I understand the submission you make about the relevant date, but I'm a little unsure as to how that applies to some of the evidence with which we are concerned. Let me take as a highlight Rajpal 1, okay? Now, in the first place, that is medical evidence obtained by your client. And given that the entire gravamen of your argument before this court is that what's needed is medical evidence, difficult to say that it's not prima facie relevant.
Oh, yes.
As to date, what Rajpal 1 says is that the condition that has been diagnosed is lifelong, and he specifically addresses the question of what its impact might have been in August, September and October 2021, which is before the committal hearing.
Yes.
So on what basis do you say that that evidence is not relevant from the point of view of date?
First of all, the dates August, September and October of 2021 don't cover anything like all of the relevant period. Particularly, we're talking, if we remind ourselves, about her state of mind at the time of trial, not before, not after, and not at the time of the commission or omission for which
But if it's a lifelong condition...
Yes, a lifelong condition, but it doesn't necessarily manifest itself in the form of unfitness to plead or unfitness to stand trial, give evidence, give instructions, unless medical evidence tells us that. And Dr. Rajpal doesn't tell us. In fact, Dr. Rajpal's reports are, if Dr. Gupta's report is going to be criticised for being somewhat thin and terse, Dr. Rajpal's is considerably more thin and terse. What is needed in my submission is something much fuller and much more complete, so that the court can have a full and proper picture of what is my client's mental state. Not only now, well, actually now isn't strictly relevant, not only at the time of trial, but right the way back to the first contempt, and arguably beyond.
I mean, I follow how you put it, but there is a difficulty. I mean, in the first place, no doctor undertaking an examination now will be undertaking the examination as at 2021 or indeed some later date. It's always going to be a matter of a doctor looking backwards.
Yes.
Which is what Dr. Rajpal was doing.
Yes.
No other doctor is going to be able to give a contemporaneous verdict because they didn't see Ms. Khan at the relevant time. And
Except possibly Dr. Chowdhury.
Dr. Chowdhury, but we've seen what he had to say.
Well, on your case, his evidence is irrelevant, because the point you've just made in answer to my question is that there is only one key date. It's the 8th of March 2023. And what comes before is irrelevant, and what comes after is irrelevant.
Well, what comes before isn't necessarily completely irrelevant. It may bear upon, and is bound to bear upon, what any subsequent doctor producing a report has to say, and all of that I would anticipate would be given to him, together with all the necessary evidence in the case, including the affidavits. So it's not completely irrelevant necessarily, and it may not necessarily be completely relevant to the court. But the point is that Dr. Chowdhury's letters are also terse and thin and don't really say very much. All of the reports so far are nothing like sufficiently complete to be able to give the court a full picture. But I accept your Lord's point, my Lord's point, that any doctor now considering the matter, even Dr. Gupta, who does at least have the advantage of having produced Gupta 1 and 2, possibly also Dr. Chowdhury, although he is not a specialist, he's only a GP, will necessarily have to look back retrospectively. To some extent, Dr. Rajpal has done that. He's only covered those months that my Lord mentioned. That's nothing like sufficient. He does say that the condition goes back to birth, but I repeat, if necessary, that condition, the condition of autism, in and of itself may not be sufficient. There has to be certain developments in addition to autism. What Dr. Rajpal and indeed my client has referred to as autistic burnout means that the degree of stress which an ordinary person might be able to sustain, a person with autistic spectrum disorder cannot. And in addition, although it's a particular type of ASD, Asperger's syndrome, so that there may well come a time, and in my submission did come a time, and that has got to be explored by further medical evidence, when she simply wasn't fit to plead, fit to stand trial, fit to give evidence, and so on, all of the things that, and Dr. Gupta identified that, albeit in a relatively terse and short report, which raises the issue sufficiently for the court to need to have more detailed medical evidence.
And then just picking up, I think, my Lord's point in a way, or one of my Lord's points, as you say, at the time of the hearings before Mr Justice Leech, on your case, there was a need for further medical evidence. That was then obtained from a specialist, informed by Dr. Gupta's reports and by what had been said otherwise. Now, Dr. Rajpal may have expressed himself quite briefly, but he was a specialist undertaking a further medical examination and producing successive reports.
Yes, can't deny that.
So why does one need more?
Because it's terse and incomplete. And the amount of time spent with my client was necessarily brief. We need something much more full and complete to be able to know. And again, it doesn't address the issue of mental capacity at all. It only addresses the issue of that it does address. And we need to know, the court needs to know, what is her mental capacity at the relevant time. Now, I appreciate that is going to require a certain element of retrospectivity, but that can be done. And indeed, Dr. Rajpal himself, to some extent, does that, however incompletely, but only in relation to fitness to plead. That evidence is necessary because, obviously, for the reasons I've said, CPR 21, it's determinative of what the consequences are for the court. I was going to make this point, but I'm reminded by my instructing solicitor. My instructing solicitor and I, of course, as you saw, my learned friend took you to the notice of change, were not instructed at the time. Indeed, there was thought to be some kind of conflict. I'm not sure exactly what that was. But I've already, I don't want to over-egg the pudding, but the fact is we were in a dilemma and still are as to exactly how we deal with this matter. On the one hand, we have a judge telling us she's capacitated, she's fit to plead, she can give you instructions. On the other hand, we have a medical report that says otherwise, and we have our own experience without getting into areas of privilege as to exactly what the difficulties are. And all I can say is there is a dilemma, a very considerable one. And the medical evidence from Dr. Rajpal was obtained at a time when she did not have legal representation, or if she did, it was behind the scenes, as my learned friend has intimated. Perhaps Mr. James, perhaps somebody else, and perhaps somebody within JFP. We simply don't know. I don't know. And therefore, the right questions were not being asked at that time of Dr. Rajpal. So that is another deficit which has got to be rectified. My lord said yesterday, well, how do you explain your client is sitting behind you and giving instructions? Well, the answer is, and this goes to the point that my learned friend has made, well, she's clearly been giving instructions right the way back to the very beginning. But that doesn't mean to say that those instructions cohere or are consistent or are logical or are rational or are sufficient to put the case before the court that should be put before the court. Now, what I have sought to do is to put submissions to the court that don't actually require instructions, but I can't ignore instructions because I'm told by Mr. Justice Leech that she is capacitated. Of course, I'm saying to Mr. Justice Leech made that decision prematurely, but nonetheless, I have to be careful that there isn't a decision based upon even a future medical report that says, well, she is incapacitated, in which case those instructions have got to be taken seriously. Your Lordship will see the dilemma that I and my instructing solicitor are in. We're doing the best we can in the circumstances, but it does mean that there are periods, both when she is represented and instructions that don't appear to cohere are given and have to be given some degree of seriousness, and periods when she has no legal representation at all, or when the right questions are not asked of the doctor who's instructed, in that case, Dr. Rajpal. That can only be solved by having a full and proper medical report, so that the court, in first instance, can revisit all of the issues, knowing what the mental state of my client is. And that's how I would put it. But all of the evidence relating to that my learned friend seeks to persuade the court to put in evidence, whether or not it passes the Ladden-Marshall test, and it doesn't, for the reasons I've said, it's all after the event. Every by admission of Miss Hodgson, it's all after the event. And so even if, and I certainly do not assert this, my client had restored to some extent her capacity or her fitness to plead, that's irrelevant. What's relevant is the time of trial and, to some extent, before the time of trial. And therefore that evidence is not going to assist the court. And in fact is likely to be more prejudicial, if I can use the expression prejudicial, than probative, because it will portray to the court apparent ability to give instructions, which could be very misleading. A, because the instructions are themselves not particularly coherent, and secondly, because they're after the event. Both of those reasons combined are reasons why the evidence should not be troubling the court by being included in this appeal. So none of what they filed disproves what Gupta 2 said at the relevant time, i.e. up to and including the committal hearing. In my submission, the proper place for that evidence, if anywhere, is in the High Court, if and when the matter is revisited there, after full medical evidence has been obtained, and a full and proper inquiry made as to whether A, the appellant was fit to plead, or B, capacitated at the time, at the relevant time or times. And after the event is obviously not relevant. In any case, what the appellant did or did not do after the second set of committal proceedings isn't determinative of her state of mind. It could not, as now, be or have been contaminated by her incapacity or unfitness to plead. We don't know, and we will not know until a full and proper medical evidence has been obtained. And equally, the respondent can file as much or as little evidence as it pleases. That will not answer the question. That question, since evidence of what the appellant did or did not do cannot replace, still less trump, proper medical evidence. At the end of the day, only the qualified practitioner can give that evidence. The way in which the appellant has acted since the committal hearing is, on one view, yet further evidence of a compromised capacity or fitness to plead, and in my submission could be argued lacks some rationality. Again, until a full and proper medical report is obtained, the court and the parties and their legal representatives are in a state of limbo. And as I said, the dilemma, where on the one hand Gupta 2, on the other hand the judgment of Mr Justice Leech. And that can only be resolved by a full and proper medical report. The true error of the judge was that he failed to stop proceedings until he had that.
Well, you seem to be re-arguing your appeal here rather than responding to the application to put in fresh evidence.
Indeed. And I was going to add, no fresh evidence can gainsay that. So in my submission, the fresh evidence will not assist the court and shouldn't be admitted. I'll just take instructions in case I've... my Lord, those are my submission, unless I can assist.
Thank you. Mr. Arcus, anything in reply?
Three very brief points, my lords, mostly really corrections and clarifications, a very old-fashioned model of reply. The first picks up my Lord Justice Arnold's point that this is a lifelong condition, and that is indeed the evidence, and I think entirely uncontroversial. But it's right also to say, I don't want the court to proceed on the basis of an incomplete picture of the evidence simply because it hasn't come out in my learned friend's submissions, that Dr. Rajpal actually deals with this in his addendum. So I might ask the court to turn briefly back to our application bundle, tab 28, page 316.
316?
316.
Thank you.
In many ways, this supports the points that the court were making in argument in testing my learned friend's submissions, but there's an important clarification to it. Inability to, this is the final paragraph of 316, inability to say with assurance whether her rigidity of thought affected her decision-making is not possible as she was not assessed at that time. And this deficit, as seen in people with ASD, can vary over time in the same person, depending on the situation they find themselves in. The condition is lifelong, but the severity of the symptoms may vary over time. That's the medical evidence.
Thank you.
Having said that, my lords, to complete the picture, it is the appellant's current case, or I should say, the corporate appellant's current case, that the deficits have continued. The deficits have continued, because in the application for an extension of time, which the court will hear in the 2024 appeal, it's tab 1 of the appellant's application bundle, those symptoms and the burnout and so on are described as prevailing all through the time period of the documents I took you to. That's the evidence in tab in section 11 of the appellant's notice in 2024-827. So it's their case that there hasn't been a change in circumstances. That's the only point I needed to really to make of substance.
Section 11 of 824.
Section 11 on page 10 of the appellant's application single bundle. One of the points made also in argument was that the key date is the 8th of March. Again, for correctness and precision, I think that's wrong. The key dates must be the period between, I mean, at least as far back as the 1st of February and the 8th of March, because the 1st of February was the day on which the trial started. I opened the case for the claimant, and Miss Khan elected not to give evidence. It's probably the case, my lords, that the relevant period for this would be slightly broader still and encompass the date on which affidavit evidence was to be served and maybe go as far back as the hearing on the 6th of December 2022. I don't think that changes the analysis as developed in arguments, but again, just for precision, I don't think we can look at one date. We're looking at a window there of a few months, just as in the 2022 appeal, we look at a window of a few months at the back end of 2021. The final point, which is fully only in reply to my learned friend's submissions, where he says, well, all of this has to be dealt with by further psychiatric evidence. We don't know whether she was subject to any of these deficits or how severely they were affecting her during the relevant period. We can't assess whether these instructions were good or not. I've made the point that they are coherent, cogent, and relevant applications and documents. The other point, procedurally speaking, is that this application I have just made has been pending since September, and there is no psychiatric evidence in response to suggest that she lacked capacity at that time. There could have been. And also, I think that's all I need to say unless I can assist you further.
Thank you very much. As I think I indicated yesterday, we're not going to rule on the application at this stage. We'll have regard to it de bene esse for the purposes of the hearing, which is not to say that it will or will not be admitted.
Thank you, my lord, for that indication. That's very helpful. And indeed, as I said yesterday, I don't actually think now, having said what I've said so far, that I need to revisit it. I think I have, if one can take as read in my submissions on the main appeal, the points I've just made on that evidence, I don't need to take the court back through it.
Yeah.
Turning then, my lords, to the Respondents' submissions on the main appeal, 868. There are 4 grounds of appeal, plus the possible addition.
I'm sorry to interrupt. I wonder if, and I apologise for my little friend, but my client has asked if it's possible to have a short break.
Meaning a 5-minute break or something longer.
10 minutes, my lord?
Yes, for what purpose?
I think she just needs a break.
I think
Appropriate accommodation, I suppose, is the heading I would put it under.
we will rise for a few moments. 5 to 10 minutes.
Thank you, my lord.
All right.
We'll see you outside.
All Franco had to do was adjourn it, give me a month off, and I would have come back and dealt with it. None of this would be happening.
And I'll say
None of this would be happening.
half a day.
But they didn't allow it. And they're sitting up there, and I've suffered 3 years. 3 years suffered because they didn't understand medical evidence.
problem not. But is it secure launching?
No, well, I mean there must be because we've got Foot and Fry and Gale. So
Yes.
it must be alphabetical. We've got Fosker over there. Freedmen on employment. I can't read all of these. I know what they are.
Fraud.
Yeah.
Yes, you're right. It must be a
So this is F2.
F to G. Gale
Who's
into the
that?
place.
On the law of tools. Fleming on the law of tools.
Yeah.
Where's it? What's Gale on easements do in the middle? I don't know. But this is F. And then it used to be. They're still obviously here. Yeah. Well, are they still being kept up to date?
The law reports.
No. 2002.
I was going to say, do they actually still publish the law reports in first?
They do.
All right.
Beg your pardon, my lord.
No problem.
Oh, sorry.
Mr. Alquist.
My Lords, I've been asked to make a point clear before I turn to the substance of the main appeal. Ms Khan wrote to the court on Monday saying that there would be a request for reasonable adjustments to be made. No request was actually ever made, and obviously there have therefore been no directions. But from the SRA's perspective, we have no objection to adjustments being made to assist Ms Khan in dealing with the stress of this hearing, such as the break we've just had. Breaks are one of the points mentioned in the equal treatment bench book for how to deal fairly with litigants with Ms Khan's condition. The reference is page 739 of the authorities bundle. I don't think we need to turn it up, but it's there. I'm sure my lords know the bench book far better than I do. We are very much happy to deal with that. Obviously, if there are going to be lots of breaks, we need to know so that we can factor it into the timetable and consider it sensibly. But you will hear no objections from me to reasonable adjustments being made, and especially as I recognise, and I will say this now, some of what I have to say this morning is going to be quite difficult for Ms Khan to hear. The judge's findings were not favourable to her, if I can put it very neutrally, and I cannot advance my client's response to this appeal without taking the court in some detail. I won't do it excessively, but in some detail to some of those findings and the severity of the findings that he made. I think it's probably helpful, given the break we've just needed, to say that now.
I'm grateful to my learned friend.
In terms of the structure of my submissions on the main appeal, there are 4 grounds of appeal, plus the point raised in the supplemental skeleton, which I think my learned friend wanted to come back to. So I'm in the court's hands on whether I deal with that this morning or not. It may now be this afternoon in any event. The 4 grounds of appeal, but we say there are ultimately 3 main issues, because the reliance specifically in ground 3 on Article 6, we say doesn't actually really add anything to the common law test in terms of the substance of this appeal. If it was the case that Ms Khan was unable effectively to participate in the trial below, then it's unfair at common law as well as a contravention of Article 3. I can entirely understand why the Article 6 why the Article 6 point is taken, but I'm not really going to address it in detail because, as far as I can see from my learned friend's submissions, or indeed our analysis, there is no difference, no material difference between the common law and Article 6 on the questions before the court. So really there are three issues. That's capacity and fitness to plead, the finality and principle and reopening of judgments, and then adverse inferences and the right to remain silent. Now, on finality of judgments, I think the court's indication of perhaps where it sits from the papers, my learned friend didn't push this, given what is said in the judgment about, well, effectively the fact that Ms Khan won on the finality point below and persuaded the judge that it was possible to reopen his decision. He just decided that, in fact, it wasn't a suitable course. I've made all of those points in my skeleton argument, my lords. My learned friend didn't make any submissions orally, and I don't propose to either. So all I need to address the court on, subject to the question of the supplemental skeleton, therefore, is capacity and fitness to plead, which is ground 1 of Ms Khan's appeal in 868, and adverse inferences and the right to remain silent, ground 4. I propose to deal with the points as follows. Firstly, to deal on the purely legal issues with the question of the Mental Capacity Act and the Pritchard test, and what the correct approach is for dealing with the issues about a respondent's ability to participate, to use a neutral phrase, in civil contempt proceedings. And secondly, to go into some detail on what the learned judge actually did, and what his analysis was, and how he approached it, and the conclusions on the facts that he drew. In dealing with those 2 points, I am going to mention some of the additional points which actually, in terms of the written documents, only feature in the skeleton argument that was filed on the 6th of February. My learned friend did so in I have no objection to that because it's clearly efficient. As we said in the last bit of our skeleton file recently, in many ways the company skeleton reads almost as a reply to our submissions. It seeks to engage with the points that we have made in 868, and in the same way I'm going to engage with those points to show that they are not an answer to my submissions. Finally then, I'll deal with adverse inferences and again deal with both the company's skeleton and a reply to ours. But turning then to fitness to plead, capacity, and generally the question of ability to participate. We say the analysis is quite straightforward, and the answer to my lord's questions yesterday about what are the deficiencies in the Mental Capacity Act, what is the interaction, what is the architecture, as my Lord Justice Arnold called it, how these two things fit together, is actually, on a proper analysis, not difficult at all. And starting in a slightly pedestrian way, contempt proceedings, certainly contempt proceedings of this nature before this court, are governed by the CPR, Part 81 in particular. The civil procedure rules are law, leaving aside interesting points of detail about the status of practice directions and court guides and so on. The rules themselves are delegated legislation under the 1998 Act, and applying them is mandatory, is not optional. It's not possible for this court to say, well, I have an inherent jurisdiction to do justice, I'm going to do something other than apply the CPR. As elementary as those points are, I make them because it follows, we say, inevitably from that the learned judge was bound to apply CPR 21 and the protected parties provisions of the CPR. He had no option to do otherwise, no option to ignore that part and borrow other concepts from criminal procedure as a replacement. And if one were to do so, as my lords puts in argument yesterday, one finds all sorts of difficulties about which piece of the criminal procedures should be adopted and which shouldn't. So do you, in dealing with fitness to plead in a civil contempt case, on my learned friend's argument, need to have two experts? at least one of whom is approved under the Mental Capacity Act. That's the point raised in argument yesterday. And similarly, how does the provision for a trial of the facts work? How does the provision for a hospital order work? Could a hospital order be made in a civil suit? Now, my learned friend had, in my submission, only incomplete answers to this, which shows the danger of simply transposing a criminal proceeding into the CPR. Having said that, it is clear and uncontroversial that contempt proceedings have much in common with criminal proceedings, and that is the point made clearly by Lady Justice Carr, as she then was in Navigator Equities and Deripaska, and I would ask the court to turn that up. It's tab 24, so page 600 of the Joint Authority Bundle. And my learned friend took the court to 79, where her ladyship said that proceedings for civil contempt are sometimes described as quasi-criminal because of the penal consequences that can attend the breach of an order or undertaking of the court. She made the point that they're criminal proceedings for the purpose of Article 6, and then gave four examples. The charges raised have to be clear. Criminal standard of proof applies. The respondent has a right to silence. There must be a high standard of procedural fairness. Once we don't take in any issue with any of that. It's also relevant, though, to look at the end of 80. There's a point about private prosecutions at the start of 80 in the quotation from Guildford Borough Council and Smith, which is not relevant to our issues. But the final wording of that paragraph is, nor does the fact that they are criminal proceedings for the purpose of Article 6 mean that they are not civil proceedings. See, for example, Masry and Consolidated Contractors, and that's the point the court saw yesterday about hearsay evidence being admissible. And again, one ends up in a situation where you say, well, quasi-criminal. That, if misused, that has the opportunity of becoming one of those Latin phrases which masks a certain imprecision of analysis. There is no such imprecision in Lady Justice Carr's judgment, but I do submit there was some yesterday. It becomes a conclusory label which asserts what it seeks to prove. The question really, as my Lord, I think it was my Lord Justice Newey said yesterday, is what is the supposed deficiency in the Mental Capacity Act and Part 21, which means that we need to go to Pritchard instead. And on that, as I heard, there was no real answer. But, my lords, I do have one to propose, and in fact, as we'll see shortly, it was the learned judge's answer as well. And I'd simply put it like this. What the Act doesn't do, we'll turn to it in a moment, but what the Act doesn't do is ask the question, what decisions have to be taken to participate in a criminal trial or indeed in a civil contempt trial? The Mental Capacity Act is focused on the ability to make decisions, but what are the relevant decisions? And just to take the references to show this in the bundle, to show this in the actual legislation and the authorities, we only actually have section 1 of the Act in the authorities bundle, but it's helpful, I think, to start with the White Book. If I can ask the court to turn to page 607. Page 607, which is in the start of CPR 21.1. It sets out the scope of the part, but crucially it also sets out the scope of the definitions. The definitions in this Part 21 carry quite a lot of weight and do quite a lot of the lifting in terms of where to find the tests. So 2A is the 2005 Act is the Mental Capacity Act 2005. Lax capacity means lax capacity within the meaning of the 2005 Act, and protected party means a party or intended party who lacks the capacity to conduct the proceedings. That's how one finds oneself in the Mental Capacity Act test. While we're looking at 21.1, my lords, I might also note subrule 1C, which expressly carves out certain types of proceedings from which the provisions of Part 21 do not apply. And all I need to say on that is that there is no reference to Part 81. There's no reference excluding contempt proceedings from the effect of CPR 21, despite the fact that the Rules Committee did make certain other exclusions. And, my lords, if we turn back up to page 605, there is a helpful quotation of section 3 of the Act.
605.
605. The foot of the page, there's a quotation headed Inability to Make Decisions. And it specifies that a person is unable to make a decision for himself if he, or if she, is unable to do the 4 things which follow. Understand the information relevant to the decision, retain the information, use or weigh that information as part of the process of making the decision, or communicate his decision, whether by talking, using sign language, or any other means. And then there are various points about adjustments needing to be made. And the fact that information relevant to a decision includes information about the reasonably foreseeable consequences of deciding one way or another, or of failing to make the decision. That's the structure of the Act, my lords, but what, as I said, it doesn't tell you is what the decisions are. What is the information relevant to the decisions that need to be taken by a litigant facing contempt proceedings? That, in my submission, is where the analogy to criminal jurisprudence might assist the court in an appropriate case. There is a wealth of jurisprudence from the criminal procedure about what it takes to have the relevant decision-making ability to understand and actively participate in a criminal trial. And if we can take just one example of that and look at the Marcantonio decision, tab 13, page 326, I'm going to go to in the authorities bundle. Starts at 324, particularly going to go to the foot of 326. The court saw this yesterday. And the applicable test in Pritchard is set out at paragraph 2, and then over the page at 4 is the citation of the Crown against M. John, and the 6 factors that my learned friend took the court to yesterday: understanding the charges, deciding whether to plead guilty or not, exercising his rights to challenge jurors, instructing solicitors and counsel, following the course of the proceedings, and giving evidence in his own defence. Now, my lords, leaving aside the point about exercising rights to challenge jurors, that is not a bad list of the sorts of decisions which one might need to take in the context of a contempt proceeding.
Yeah, well, even the reference to challenging jurors is out of date because peremptory challenges to jurors by the defence are no longer allowed in criminal proceedings.
There are a few points, my lords, where, including whether the question of fitness to plead is determined by the judge or the jury, where there has been a development since some authorities were decided. I don't think any of the points are particularly in issue.
I don't think 6 is exactly an issue in this case, or not in quite the terms I'm thinking about. I mean, you have to make a decision as to whether to give evidence. There might be a further stage, are you in a fit state to give the evidence? That doesn't fit the Mental Capacity Act quite so well.
No, my lord, it doesn't. But there we would not be into the question of capacity to make decisions, but we would be in a territory where the CPI is and the court exercising its powers under the CPI is well used to making adjustments for witnesses. And indeed, the reference to the Equal Treatment Bench Book, which I mentioned a few minutes ago, sets out all sorts of ways in which it could be done. So if someone wants to give evidence and is not capable of doing so, and is irremediably incapable of doing so, there may be a question of fairness of the proceedings. But that's separate from a question of capacity or fitness to plead. Because the plea has been given in some way.
No, the two things are surely inextricably connected. If the person in question lacks the capacity to give evidence, then they can't coherently decide that they wish to give evidence.
Lord, I'm not entirely sure that's right. Not as an absolute rule. It may very, very often be the case that the two go together. But there must be, I think, and indeed the condition in question in this case might be one of them, a situation where a litigant is sufficiently aware and can, with the assistance that the Mental Capacity Act requires you to take into account, make an informed decision about whether it would be in his or her best interests to give evidence and whether they want to, but nonetheless be unfit as a matter of mental or physical disability actually to be able to deliver that evidence. Certainly if we're talking about being subjected to a cross-examination. If giving evidence means putting in a witness statement, which one's been able to write in advance with assistance, then maybe the distinction really is very close. The ability to undergo the rigour of cross-examination is, I think, a separate question.
I mean, it may be capable of possible to frame it in the same way in terms of, are you able to decide how to answer or something? I don't know.
Possibly, my lord, yes. But actually, this picks up the next point I was going to make, which is that, as my learned friend has said, in the criminal authorities, it's clear, fitness to plead is a single indivisible test. And if you're unfit to deal with one of the things that is set out as part of the list of factors, you cannot stand trial. And in the Marcantonio case, the Court of Appeal referred to the Law Commission's then recent proposals that actually maybe there should be a separate ability if you're fit to plead guilty and you want to plead guilty, but you wouldn't be able to undergo cross-examination. Say you can't plead guilty because you can't deal with the cross-examination, which you know you don't want to do and will never happen, is a little bit strange. And that's the point in 8 in Marcantonio. But nevertheless, that's the law, the Court of Appeal said. Well, in my submission, the civil court, informing itself by reference to the jurisprudence as it's developed in the criminal law, would not be straitjacketed in the same way. Because the test is the Mental Capacity Act test, and all we are doing is using this authority to inform the question, what sort of things does a respondent to a contempt application need to be able to do? And having made that point, might I ask you to turn to the sanction judgment of Mr Justice Leech, core bundle tab 11. Starts at page 96.
No, what page do you want?
I want 109 to start with. and this is in the section, paragraphs 29 to 31 in particular. This is in the section where the learned judge is summarising his reasons in the confidential schedule and saying there's no real prospect that Ms Khan or those representing her can persuade the court that she's a protected party within the meaning of CPR 21.1. If we then go to the confidential schedule, having shown the court where it was effectively put into its relevance, the relevant analysis then continues. I've lost. My reference. Mullers, I may need to give you the reference in a moment when I find it again. The point that I wanted to take the court to in Mr Justice Leech's judgment is that he said that one may consider what is said in the case law on Pritchard in asking the question about capacity.
Is it paragraph 14?
It is, my lord. Yes, I've just found it on the using the search function. Paragraph 14 of, in fact, the main.
Page 124.
Page 124. Yes. He said, I accept at a high level of generality their direct claim concerns, and that if I accepted Dr. Gupta's evidence without qualification and found that Ms Khan was unfit to plead for the purposes of the criminal proceedings, then this would be a powerful factor in deciding whether she lacked capacity for the purposes of the 2005 Act. He moves on, and I'll come to this in a moment. He says, I also accept that this would be a strong reason for refusing to permit the committal application to proceed. And so, well, as the point, I'm elaborating on that reasoning a little perhaps, but the point really being made here is, if you fail the Pritchard criteria, that may very well be a strong reason for saying that you fail the test under the Mental Capacity Act for being able to participate in the proceedings. The final point that His Lordship made, and this I think wasn't fully argued below and in the end wasn't relevant, is that one of the difficulties with reading across from the criminal law jurisprudence is that the outcome of a decision on lack of capacity and a decision of fitness to plead is very different. If you are found to be unfit to plead, then the provisions of the 64 Act, which possibly include detention under a hospital order, are engaged. There are other outcomes as well, including an absolute discharge in an appropriate case. But there's the trial of the facts and the possibility of a hospital order being made. The result under CPR 21 isn't to call a halt to the entire proceedings and make it impossible to proceed. The default position under CPR 21 would be to call a halt only until a litigation friend is appointed, and then the matter proceeds with the litigation friend giving instructions instead. And I think what Mr Justice Leech was aiming at in the last sentence, where he said it would also be a strong reason for refusing to permit the committal application to proceed, is if you had a litigant who lacked capacity to understand the committal proceedings against her, was unable to decide whether to give evidence or not, and unable to give evidence in her own defence, then appointing a litigation friend to deal with the contempt trial, and possibly then sending her on a committal order to prison anyway, is not necessarily a particularly fair outcome. Maybe that in this particular circumstance, because the liberty of the subject is at stake, that a litigation friend might not be an apt answer. And I think that's what my lord, when he dealt with Mr Justice Leech, when he dealt with it below, is really saying when he says that this would be a strong reason for refusing to permit the committal application to proceed. There'd be an issue of fairness which might not be curable with a litigation friend, differently from another civil trial. Now, whereas in some ways one might think that's very similar indeed to my learned friend's submissions yesterday about applying Pritchard by analogy. I think it's a little more precise, and that's why I've gone through it. But I've also gone through it because it's important to say that the judge accepted that he could take Pritchard into account in that way. And so, although it took until, by my note, almost, I think, 3 o'clock yesterday to turn to the question of the judgment and the underlying evidence, what this appeal is really about is the judge's findings of fact on Gupta 2. It's not really about the Mental Capacity Act versus the Pritchard test. Despite the fact that grounds 1 of both 868 and the company's 2024 appeal assert, at least in the grounds, that the Pritchard test is the right test and the Mental Capacity Act is the wrong test, that's the primary case, and the analogy is only an alternative case, really this case isn't to do with what the test is at all. It's to do with the trial judge's assessment of the expert evidence before him and how he dealt with the part of the status application which concerned adjournment. Because he acceded to the point that he might well have reopened the liability judgment if he'd been persuaded that the evidence justified it. And that's why I said yesterday that I do need to go into Gupta 2 and the wider evidence in the confidential schedule in some detail. I will do so with regard.
Just before we do that, there's something that I found a little odd in approaching this case. And please, I'm not intending to criticise the advocates. I mean, I appreciate that both advocates have done their level best to assist the court in what are unusual and difficult circumstances. But given the issue which you have identified just now, and I think rightly identified, I find it a little odd that we don't seem to have put before us the learning which exists as to the proper approach to the assessment of medical evidence. So we have cases like Newey Carr, Forrester Ketley, and so on, in which courts have addressed the question of what the proper approach to uncontroverted but nevertheless possibly unsatisfactory medical evidence is.
That is right, my lord. And the answer, without wishing to sound impertinent, from my perspective at least, is the rules on the citation of authorities in the Court of Appeal.
Right.
We have in the bundle GMC and Hyatt, 2018 decision of the Court of Appeal, which cites and quotes the relevant provisions of Ellis Carr. And I was going to take the court to that this morning.
Right. Well, that's in which case the explanation is it's my ignorance because that's not one I'm familiar with. Okay.
GMC and Hyatt's mentioned in one sentence in my skeleton. We mentioned it below, and I noticed actually in preparing the oral submissions that I've given the wrong paragraph reference. So I may not have assisted there, but we have GMC and Hyatt.
Might it be helpful to look at that now? Because I mean, given
I'm very happy to, my lord. Yes, I was going to give you the structure of the confidential schedule first, and
I think we've got that.
But let's go straight to Hyatt, and I will also deal with Newey at the same time. It's tab 15 of the authorities bundle.
Page 370.
Yes, my lord. And in particular, we will be going to 383. But just starting at 370 and 371, there's a tramline section for paragraphs 1, 2 and 3, which summarises the questions before the court.
383?
371 I'm going to first, but 383 is the key passage.
Thank you.
It's an appeal from the administrative court, a second appeal from the administrative court, following an appeal from the Medical Practitioners Tribunal to the administrative court, in which a submission had been made to the administrative court that the tribunal, in paragraph 2, had erred in failing to have regard to the relevant medical evidence before the permitting the hearing to continue in the absence of Dr. Hyatt, who was the registrant facing disciplinary proceedings. And the judge in the administrative court allowed the appeal on that ground and remitted other matters for reconsideration. And the GMC appealed on the basis that the High Court had erred in principle in the consideration and analysis of the decision not to adjourn. And with that legal background, I think we can move over the factual evidence about what the disability was and look at the passage starting at paragraph 37 on page 383.
And I presume you particularly rely upon the second sentence. There must be evidence that the individual is unfit to participate in the hearing.
Among other points, my lords, yes, I do. It's not just that there must be evidence, but also what is said in the rest of that paragraph, after the reference to the Jaffery case. That evidence must identify with proper particularity the individual's condition and explain why that condition prevents their participation in the hearing. See Levy and Ellis Carr. And then there's the point about challenging in the Divisional Court's decision in Brabazon Denning. And then Mr Justice Norris's judgment in Ellis Carr is quoted at some length. The particular point that I would take from that paragraph 36 quotation, paragraph 36 of Mr Justice Norris's decision in Levy, is actually at the top of the following page. It's all helpful information as to the standards of what the medical evidence should be, but the key point, I think, on the argument on the appeal is where he says no judge is bound to accept such expert evidence. Even a proper medical report falls to be considered simply as part of the material as a whole, including the previous conduct of the case. The letter on which the appellant relies is wholly inadequate.
But I assume you would accept that it can't be disregarded either.
No, of course not. And the confidential schedule demonstrates that the judge absolutely didn't disregard it. He took it, he went through it in detail, examined it carefully.
Yeah.
And simply,
But I think when I say disregarded, perhaps I should have rephrased my question. What I meant to say was, as we know from Newey and Griffiths, it's not appropriate for the court to cross-examine an expert in the expert's absence.
no, my lord, I'm going to come to Newey and Griffiths and the question of cross-examination separately. It's a slightly distinct point.
Okay.
Not least because that's a question about trials and oral evidence at trial. This was an adjournment application, and therefore the authorities here in Hyatt are particularly pertinent, because you'd very rarely, in my submission and certainly in my experience, have oral evidence from experts on an adjournment application. We have also Forrester, Ketley and Brent, and another which my lord mentioned. In which it's emphasised that a late application for an adjournment on medical grounds is not a rare occurrence, and an adjournment is not simply there for the asking. And there's some discussion of the effect of stress.
So you're in Forrester.
I was in Forrester, yes, just very briefly. Well, it was really to say that it's there, as is Mobley Smith in paragraph 40.
Just on Forrester, the quotation from Lord Justice Lewison. He says there the court will only interfere with an exercise of discretion if certain criteria apply. Is it your case that that principle applies in this case or not?
Yes. I was going to come to that when when going through the judge's reading. That's why I was going to do it in that order. But
Yes.
It's perfectly fine to do it in this order. What I will be submitting when we go through Mr Justice Leech's judgment is that he has made no error of principle in his assessment of the evidence. He has concluded on good grounds, or at least grounds that were open to him, that there was no real prospect of any further expert evidence, making him reach the conclusion that Ms Khan was unfit to plead, or lacked capacity for the purposes of the 2005 Act, I should say. And that assessment by the judge who had heard the trial and had all the evidence in front of him is not one that can be lightly impeached in this court. And as far as I can see, my learned friend really accepts that, because he has been forced to say that the authorities on the fact saying that the judge may order an adjournment for further expert evidence become must in the context of civil contempt proceedings. A submission for which, as far as I can see, he cited no authority. And we say it's wrong. But I'm getting ahead towards my conclusion, my lords, rather than taking the court through higher. The last reference I was going to mention here is 40. And that's Lord Dyson, who was Master of the Rolls in Mohun Smith and TBO Investments.
Page
384, paragraph 40 of Hyatt. It says, nothing I say in this judgment should be interpreted as casting doubt on the guidance given in the Levy case. Generally, the court should adopt a rigorous approach to scrutinising the evidence adduced in support of an application for an adjournment on the grounds that a party or witness is unfit on medical grounds to attend the trial. So the Court of Appeal has emphasised that a rigorous approach is appropriate. That is the polar opposite in my submission from what is being pressed on the court now, to say, well, actually, in contempt proceedings, all you need is the question to be raised by a medical expert, and however inadequate or however deficient or however unsatisfactory their evidence must be, the only option open to the court is to adjourn so that these questions can be dealt with.
I assume you also want paragraphs 42 and 43 over the page, which have been sidelined.
Yes, my lords, and that was going to bring me back to the Tynaz case. And that Tynaz case and the Masri case that my learned friend took you to yesterday is the point I was making about may versus must. The may quotation, we have it there in Hyatt. If I can turn up as well briefly Solanke, which is the previous tab, so page 349 it starts, and the relevant passage to go straight there is 358. Again, the court saw this yesterday. Paragraph 32 starts the relevant analysis, and it said on
page 358?
358, paragraph 32. It said on the strength of the Turlock and Berezovsky decision that the question is not, it has to be satisfied that the decision to refuse the adjournment was not unfair. And it's the same point as my lord mentioned from the Forrester case about the scope of the decision-making responsibility of the trial judge and the proper function of this court.
Just comparing that with the quotation from Forrester back on page 384, where Lord Justice Lewison speaks of only interfering with the judge's exercise of discretion if the judge has taken into account irrelevant matters, ignored relevant matters, or made a mistake of principle. Does that quite tally with what's said in Solanke, where it said the jurisdiction of this court is not confined simply to considering whether irrelevant factors were taken into account and so on? It's a matter of fairness.
Well, it goes. There's learning on this in actually in this Solanke decision on the tension that might be put there, and one finds this in the quotations from Turlock and Tynaz. The question Turlock, particularly, paragraph 34, top of page 359. Paragraph 18. Our approach to this question, said Lord Justice Sedley, is that the test to be applied to a decision on the adjournment of proceedings is not whether it lay within the broad band of judicial discretion, but whether, in the judgment of the appellate court, it was unfair. And then at 20, they make the point that it's not to say that there's only ever one outcome which is fair, and there may be a range of fair outcomes. So if you're in a situation where there is a range of fair outcomes, and there are maybe different ways of resolving a procedural problem, then you are in the judicial discretion as to case management territory in its broadest sense. My suggestion, given we're talking about two distinguished judges of this court, my suggestion on any tension as between Lord Justice Sedley and Lord Justice Lewison's judgments would be this, that the assessment of the evidence as to the question of unfairness is in its full strength a question for the trial judge.
Is a question
for the trial judge. The legal question of whether the judge correctly directed himself as to the assessment of that evidence, or as to whether on the evidence as found by the judge the trial was fair within the common law principles, is a question of law. And that's the point emphasised by Lord Justice Sedley in 18 of Turlock. The question of whether a tribunal was acting in breach of the principles of natural justice is essentially a question of law. So on the facts as found by the judge, was there a breach of natural justice? That's a pure question of law. What Turlock tells us. I recognise there is a degree of tension there, but I think that's the correct way through it. And in my submission, as regards this case, the key point is the findings made below. Because as I took the court to in the open bit of the judgment, the judge said if he had thought the evidence was strong enough, he would have adjourned. He would have been willing to adjourn to hear evidence and possibly to set aside the liability trial judgment entirely if he had considered that the evidence justified it. And he didn't for the reasons he set out in his confidential schedule. And when we are dealing with that question, that is a question which really ought to be left to the trial judge in the absence of all the well-established points which might justify this court intervening on findings of fact and the approach to the evidence below. I could turn that into a white book, my lords, but I'm quite sure, I don't need to go through the recent Supreme Court decisions on the proper function of first instance and appellate decision making. The final point on the relevant learning on adjournments is that Mr Justice Leech also directed himself by reference to the decision in Avocade, decision of Adam Johnson QC, as he then was, sitting as a deputy. Again, in light of the fact that we've already got 30 authorities in this bundle, we didn't put in another decision of a deputy judge. I mean that with no disrespect to Mr Justice Adam Johnson. We didn't put in another decision at first instance setting out very similar principles. We've got Hyatt, which summarises the case law on adjournment applications. I hope that answers my Lord Justice Arnold's concern. I promised to go to Toohey as well, which I can do now. I was going to show you the criticisms made of Gupta, Dr. Gupta, and how they are reflected in the decision in Toohey. Well, they hit the categories in the decision in Toohey, but since we're in the authorities bundle, let's look at the exceptions articulated in Toohey, and then look at Dr. Gupta's report and the judge's treatment of it. The first point on Toohey, as I said a few minutes ago, is that in my submission it doesn't apply, certainly doesn't apply with equal force to a Part 23 application, whether for an adjournment or to reopen a judgment, or anything of the nature of the applications that were made to the judge below. There may be cases, I accept this, there may be cases where fairness requires cross-examination. The judge feels he can't really consider the evidence or deal fairly with the application without hearing oral evidence. But as we all know, my lords, oral evidence on a Part 23 application is very rare indeed. And so to read the decision of the Supreme Court in Newey as suggesting that far from being very rare, that should be mandatory whenever there's a dispute as to expert evidence, or indeed factual evidence, because the same point would apply to witness evidence, must be wrong. That cannot be what the Supreme Court intended. Otherwise, I'm sure Lord Hodge would have said that there should henceforth be an opportunity for cross-examination of any contested evidence in a Part 23 application.
I mean, I suppose it rather depends what sort of Part 23 application you're thinking.
That's why I say, my lord, there may be cases where it is an appropriate situation, and I have indeed acted in one, which was the Republic of Djibouti and Bore case, where there was an allegation that a solicitor had misled the court on a freezing injunction, and Mr Justice Flow, as he then was, held, I think, effectively a 5-day trial on the set-aside application, at which oral evidence was heard, and there were opening and closing submissions. It can be done, but it is not done often. And one cannot simply point to Newey and say, well, look, there was no cross-examination, therefore procedural unfairness.
I mean, one complication, I suppose, is very often on interlocutory applications, the law doesn't require you to make a decision as to the facts. Say you're applying for an injunction, you have to show there's a serious issue to be tried. The court doesn't have to choose between one witness statement and another.
Often it doesn't, my lord, but in many cases it does as well. If one had an application for relief from sanction based on medical evidence, or an application to set aside a default judgment based on medical evidence, which may be very significant applications indeed, you would expect them to be dealt with only on the basis of written evidence, even if that was medical evidence as to the effect of a deficiency and whether that of an illness or other deficiency, and whether that constituted good reason for an extension of time to be granted, or relief from sanction to be granted. Indeed, my lords, actually, this appeal is going to need to do that on the 2020 on 829, and on the application for an extension of time in the 2024 appeal. And there's never been any suggestion that this court should hear Dr. Rajpal, or that he should be here to be cross-examined. So there are, I accept, my lord, there are cases where actually fairness may require cross-examination. And as I say, the learned judge said if he had thought the evidence was cogent enough to raise the question properly with a real prospect that he might find that the appellant lacked capacity, he would have done that. So he was open to that possibility. And so that's the first point on Newey, my lords, that you can't simply read this and the points made about cross-examination here as applicable to Part 23 applications.
And certainly, I think it's the case, isn't it, that there is absolutely no reference in Newey to the learning on adjournments.
I don't believe there is. It's perhaps I might check that over the short adjournment just to be able to give the court a proper answer.
I mean, looking at the list of authorities cited, we do not see.
We don't see the ones
any
that
of
we've
these
just gone
names.
through. So it's unlikely that there is. Whether there's an indirect reference by relation to one of the many cases where this is considered, I'm not quite as confident as I'd like to give a certain answer. But I'm fairly confident my lord is right. And certainly it's not, in my submission, actually inconsistent with what the Supreme Court said. If one looks at the exceptions to the general rule, one finds from 61 of the judgment onwards, so that's page 667. And that confirms, by reference to Phipson on evidence and the Brown decision, that there is a long established rule as stated in Phipson, and we see that further up is the point the friend takes, that evidence shouldn't be discounted without cross-examination. But it's also said there are also circumstances in which the rule may not apply. Several come to mind. And then he says first, the matter to which the challenge is directed is collateral or insignificant. So we have the first example in 61, and then there are 7 of them running all the way through to 68. The ones that I would particularly flag as relevant when we turn to Dr. Gupta's report and Mr Justice Leech's analysis of it are 63. First, there may be a bold, I think this should be bold with an A, really, rather than with an O, but that's by the by, a bold assertion of opinion in an expert's report without any reasoning to support it. What the Lord President Cooper in Davian Magistrates of Edinburgh described as a bare ipsa dixit.
Actually, it's an interesting question, whether it's bold or bald, I don't know.
It could be both, my lord.
Yes.
The reference to bare might suggest bold.
Bold or bold?
I don't think anything turns on it, my lord. It's just
Bare might be bold, my lord, not necessarily bold.
But it's the bare ipsa dixit point, and an unsupported assertion. And it said reasoning which appears inadequate or open to criticism is not the same as bare ipsa dixit. That's the first point, 63. 64 is also relevant. Fourth, there may be an obvious mistake on the face of an expert report. We've just been referred to this possibility in paragraph 94 of his judgment and cited Woolley and Essex County Council as a useful example. In Hull and Thompson, which is the case of the New South Wales Court of Appeal, the Associate Justice Rolfe expressed the view that such a circumstance would be where the report was ex facie illogical or inherently inconsistent. And then there's a citation of the Tallina 1946 Lloyd's Law Reports 94, where Lord Justice Scott spoke of the court rejecting an expert's evidence if he says something patently absurd or something inconsistent with the rest of his evidence. And that point about internal inherent inconsistency is one I'd ask the court to note as we go through 2E. And then I think that links in my submission with both 66 and 62. I might say that the last criticism made of Dr. Gupta might fall under either of these. 62 refers to refers to a statement of fact that might be manifestly incredible, and an opportunity to explain on cross-examination would make no difference. Incredible is a strong word, my lord, but the point is if it's just not plausible, the facts on which the expert has based his opinion, then it may be that cross-examination is unnecessary. And 66 is a similar point. The witness's evidence of the facts may be contrary to the basis on which the expert expressed his or her view in the expert report. And then again we have Hull and Thompson, where the Court of Appeal of New South Wales spoke of the report being based on an incorrect or incomplete history, or where assumptions on which it is founded are not established. So the rule in Brown and Dunn, as emphasised in Toohey and Griffiths, is obviously important constitutional safeguard, but it is not of universal application, and the Supreme Court was very clear about that. Having mentioned those points on potential existing examples where the court might well say actually cross-examination is unnecessary, I would then turn, unless the court has any further questions on those authorities, to the confidential schedule.
Lord Hodge says these ones come to mind. and is concerned with when there should be cross-examination. Plainly, well, take the adjournment example. There is normally no occasion for cross-examination. And it's really very hard indeed to think that the Supreme Court had in mind that whenever, at a hearing, at a trial, someone asks for an adjournment and produces something from a doctor saying they're unfit to work, or something, a sickness note, which actually is all too common, you have to adjourn unless the doctor is there to be cross-examined, which inevitably they won't be.
It would be a radical change in the way such applications are dealt with. And certainly, it's not the case that Dr. Gupta was there at court, ready to be cross-examined, or there was any suggestion that he ought to be on the 8th of March. The request for an adjournment to allow the SRA, if it wished to challenge Dr. Gupta's evidence, to put in good evidence of its own, and then if there was disagreement, for there then to be cross-examination.
I mean, I do think this case may be different, but in the average case where someone comes along or doesn't come along, sends the court a sickness note, really the Supreme Court can't have been intending to say that you call a halt necessarily to the proceedings at that point, and were that the law, then it would have a major impact on the conduct of civil litigation.
It would. And how the Supreme Court would reconcile that with the overriding objective and the practicalities and pressures of court time is something that you would think that 5 very experienced justices of the Supreme Court would note and might mention, if that's the way to read their judgment. And if one wants to put this another very technical way, can we read Newey as impliedly overruling all the decisions of the Court of Appeal that we were looking at on the adjournment applications? Plainly, in my submission, not.
Just thinking round this, one conceivable distinction is that Brown and Dunn and so on are concerned with whether the substantive case has been made out. Whereas, plainly, if there's a question of adjournment for medical reasons, that doesn't bear on whether the substantive claim has been proved or not.
No. Well, that would be a point of distinction in many cases.
You're doubtful about whether it would be a secure distinction across the board.
And particularly, to be honest, I'm pausing because I wonder if I'm about to make a point against myself. I'm not sure it would be a secure distinction in the case of question of capacity and contempt proceedings.
Well, I see that.
But also, the point is the one you were making earlier, which is what we're concerned with here is a fair trial. And if an adjournment is wrongly denied on medical grounds, when it should have been granted on medical grounds, then there isn't a fair trial.
Exactly, my lord.
And a fair trial actually matters more than the substantive outcome.
It may do, my lord, because it is right to say that if the trial was unfair, it doesn't matter if this court thinks that actually, when it's remitted for retrial, the same conclusion will be inevitable. It must nonetheless be remitted.
That's why it's the alternative basis for an appeal under Part 52. Either the decision of the court was below was wrong, or that it was unjust by virtue of procedural irregularity.
Indeed, my lord. In fact, serious procedural irregularity.
Yes.
I'm going to turn to that on the adverse.
Just before you do that,
but I haven't done the confidential schedule yet, but that will form part of my submissions.
still thinking around things rather than worrying necessarily about the facts of this case. Was it in Hyatt? There is the idea that if you can see it's not going to make a difference, then you don't worry about it.
My lord, that's right. I think there is reference in one of the decisions in Hyatt. I can't immediately. One of the decisions quoted in Hyatt. I can't immediately lay my finger on it. But that must be right under the overriding objective. Because if it's clear that it's not going to make a difference, how is it consistent with the overriding objective to adjourn and have all the wasted costs and time and delay associated with an adjournment and additional expert evidence if it's quite clear from the outset it's not going to make a difference? There is no unfairness, certainly no serious procedural irregularity, if it's never going to make a difference.
I think I must have in mind paragraph 43 of Hyatt, for what it's worth, where it said, it seems clear that if a tribunal is being criticised for not undertaking further inquiries, the complainant must be able to demonstrate that those further inquiries would have been material and would have been likely to have led to a different decision.
Yes. And then there's the citation from Lord Justice Henderson,
Yes.
which refers, as my Lord Justice Arnold did, to 5221(3)(b).
What was it again? 50?
5221(3)(b), and the test of the hearing below having been unjust because of a serious procedural irregularity. And in many ways, as we're exploring the authorities here, we keep coming back to the same points. And that's because really the authorities do all speak with one voice. That there is no obligation to adjourn a hearing to deal with further medical evidence, orally or in writing, if the court is satisfied that it is fair to proceed on the evidence before it and the answer is clear. Now, my lords, on the confidential schedule, the approach I was going to take is actually similar to the approach I took with Hodgson 1, which is to look overall at the learned judge's reasoning and then do a deeper analysis of one or two points. And in particular, again, to do so with regard to what is called in Solanke the appearance trap. There are various criticisms made. If I can just turn up the core bundle, tab 11, page 125, start with criticism of Dr. Gupta's report. I hope I can take most of the pretty quickly. The first criticism Mr Justice Leech made is that Dr Gupta's instructions didn't expressly advise him to consider whether Ms Khan was fit to plead at criminal proceedings, and his reasons for addressing the Pritchard test were unexplained. And my learned friend sought to gloss this yesterday with, I think, what is a new point, that it was necessarily implicit in his instructions. But in fact, actually, Mr Justice Leech had dealt with that already, because he says at 15, I do not criticise him for considering the issue if he thought it was his duty to express an opinion. But the point which follows in that sentence, which is critical, is he did not explain what symptoms or behaviour led him to make that decision or to reach the conclusions which he did. His reasons for addressing the Pritchard test are, therefore, unexplained. That's perhaps the more pertinent point in the criticisms, and in terms of the weight to be placed on the expert evidence, the failure to explain his reasons for addressing that test is relevant. Then there's the point about the fact that Dr Gupta had not considered or even been provided with two of Ms Khan's 4 affidavits, and he had not expressed any view at all on her 4 affidavits when considering the issue of fitness to plead. And that's the one I'm going to do perhaps a deeper dive on, but I'm going to come back and do that once I've run through everything. That's 16. At 17, the learned judge pointed out that Dr. Gupta had not set out the specific reasons in Gupta 2 why he had now formed the view that she was unfit to plead when he hadn't formed that view before. And my learned friend made the point, well, it's a much more thorough assessment and so on. It was in person rather than by video conference. Those may be accurate explanations, but they are points made by counsel in answer to the criticism, and not points which Dr. Gupta explained when he served a report which was inconsistent with his previous report. And the learned judge, in my submission, was clearly entitled to take into account the failure to explain the change of position. There's another point in that Dr. Gupta had included in his report a summary which referred to Ms. Khan's erratic behaviour and the irrational position that she had adopted. And this is 18 to 20. In fact, he described one of her positions as delusive. And as I submitted to the learned judge, as recorded in paragraph 19, it's important to emphasise section 1.4 of the 2005 Act. A person is not treated as unable to make a decision simply because they take an unwise decision. An unreasonable litigant, a vexatious litigant, nonetheless has capacity to litigate. Or rather, they may have capacity to litigate. Vexatious litigation may flow from a complete inability to understand what's going on and the appropriate behaviour, but it doesn't follow from one that the other is true. And so when Dr. Gupta refers to the erratic decisions, an irrational position that no solicitor acting rationally could ever adopt, that's not the test under the Mental Capacity Act. In fact, it's specifically not an analysis which is permitted under the Act. And the learned judge was right to make that point. I should emphasise there is a postscript to the confidential schedule where he corrects the point made at 20 that he had not seen Dr. Gupta's instructions, or all of them. But he says that correction made after the judgment was written doesn't change his analysis, because to the extent that it's just copying from the instructions, that further casts doubt on the independence of his decision, of his opinion. And then paragraph 21 through to 23, we have a series of submissions, a series of criticisms about internal inconsistency between Gupta 1 and Gupta 2. And I hope as I'm going through this, I'm not constantly referring back to Newey, but I hope the court is following the relevance of the exceptions that I made in Newey about internal inconsistencies with the evidence, points which are manifestly unsustainable on the evidence that witnesses of fact have given, and so forth. The inconsistencies 21 through to 23, both in Dr. Gupta's own reports and in the inconsistencies with the other evidence he had before him. And I can't really improve very much on the confidential schedule here. But to take one example, 21.1 quotes Gupta 1 as saying that Ms. Khan was cognitively alert to understand the court proceedings, and Gupta 2 said that she only had a superficial understanding of the matter and the seriousness of the proceedings, and that she may not accurately comprehend the discussion. And the point which then actually flows quite neatly into 22 and 23 is found at 21.2, that Gupta 1 had said Ms. Khan can put her views, opinions and wishes in her defence, which Munnels may note echoes the criteria that my learned friend went to yesterday in the Crown and M. John case and the Mark Antonio case, as to fitness to plead. So on its face, Gupta 1 says yes, fit to plead. If he had actually turned to the question of that test. And in Gupta 2, he expressed the view that she could not provide me, Dr. Gupta, with any relevant opinion or views in her defence. Now that change of position is unexplained. and there's another one about the consequences of actions in 3. But building then on the inconsistency in whether Miss Khan could provide Dr. Gupta with any relevant opinions in her defence, His Lordship made the obvious and, in my submission, compelling point that the court has to have some understanding of how Dr. Gupta's conclusion that Miss Khan could not understand the proceedings or provide any relevant opinion or views in her defence sits against the fact that Miss Khan had filed 4 affidavits setting out her opinions, views and evidence in her defence. And 2 of them hadn't been provided to him, so I make no professional criticism of Dr. Gupta for that, obviously. 2 of them had, and he didn't refer to them. So the court was left without any evidence from the medical expert as to how it might be said that despite Miss Khan having filed 4 affidavits setting out her views in her defence, she was actually incapable of doing so. My lords, that brings me very neatly to the appearance track, and I notice it's
So this
1
would be a
o'clock.
convenient moment.
That is a convenient.
Can I just be sure we don't have the 4 affidavits before us, do we?
No, we don't, my lord. I'm going to take the court through 3 specific findings of fact in the liability judgment to make good that His Lordship was entitled to say that the affidavits betrayed a thorough understanding of the charges.
Thank you.
If it would assist the court to have a set of the affidavits, I can have them printed over lunchtime.
I think that might be prudent.
I'll bring 3 files with...
They're that substantial, are they?
Oh, no, I mean 1 for each of your lordships with Khan 1 to 4. I think perhaps best not to include the exhibits.
Yes. 2 o'clock.
Thank you.
Alright.
Not that far.